If you have a blended family, it is vital that you have an estate plan. Hi, my name is Alec Osland, and I'm an attorney at the Yanowitz Law Firm, where we've been assisting families with wills, trusts, and probate for over 30 years. Recently, I met with a client who came to us after the death of a step-parent, as they were wondering what are the next steps. Their father had died years earlier, and all of the assets that the father and the stepmother had were joint assets. So everything automatically went to the stepmother upon her father's death. Now that the stepmother had passed away, they were wondering, what do we need to do now to gather the assets? The parents, they had never done any sort of estate planning, and they had nothing listed on any of the beneficiaries on any of the accounts. Big question here, what happens with the assets? Well, essentially, the fact is all of the assets are just going to go to the stepmother's children and descendants. Because the stepmother died without any estate planning documents, her estate would go through probate, and the assets are going to pass via the Minnesota laws of intestate, which is essentially a state statute which identifies how assets pass when someone dies. Because the father and stepmother were joint owners on all of the accounts, the stepmother automatically took ownership of all the assets, and a probate was not needed when the father died. If a probate had in fact been needed when the father died, then the stepmother would have been entitled to the first $225,000 of the estate, and the remainder would have been split equally with the father's children and the surviving spouse. However, since there was no probate, all of those assets just automatically went to the stepmom since she was the joint owner. Since now she had all of those assets in her name and she had no beneficiaries, no other joint owners listed on all of the accounts, all of those assets now fall to her estate, and the law says that everything now goes to her descendants and that the descendants of the father are not going to be entitled to anything, which is now in turn going to cause a lot of family issues because now you have a bunch of people who feel kind of swindled and taken because essentially all of their potential inheritance went to their step brothers and sisters. How could have this been avoided? Well, the father and stepmother could have had an estate plan. If they had an estate plan, they would have been able to identify what happens when one of them dies and what happens when both of them dies, instead of now we are relying on a state statute which identifies how these assets are passing, and it is completely cutting out the father's descendants. So again, if you have a blended family, it is so incredibly important that you have an estate plan in place that is going to identify your goals and protect you, and also protect your children and any other descendants as well. Make sure you subscribe to our YouTube channel to find out when we post another video. Thanks. Have a great day. Bye.